I'm now going to introduce Anna. Now that we've got everything sorted, I think the world must be full of gremlins today. So Ana Sambold is one of the leading alternative dispute resolution professionals in the US. She's a California-based attorney, mediator, and arbitrator with over a decade of experience as a conflict resolution specialist. She's the founder and principal of Sambold Law and ADR Services, and has served as a neutral in over 1,000 cases across a broad spectrum of civil litigation matters involving commercial, insurance, property, employment, and succession, multinational and multilingual clients. She conducts mediations in person, online, and in 3 languages, including English, Spanish, and Spanglish, which totally counts. She's, of course, an IMI certified mediator and is in the neutral panels of the AAA, ADR Services Inc., and several US court, federal, and state agencies. She describes herself as an unstoppable advocate for ADR and a devoted leader in the legal and ADR field. She currently serves as the ABA Dispute Resolution Section Educational Programming Officer, ABA Advanced Mediation and Advocacy Skills Institute Co-Chair, California Lawyers Association ADR Committee Past Chair, and San Diego County Bar Association ADR Vice Chair, among other leadership roles. Above all, and most importantly, she is passionate about the Singapore Convention and has been following all of its developments. She was also invited by the Singaporean government to attend the signing ceremony of the convention. So welcome, Anna.
Okay, good morning, everyone. I'm so glad to be here today to talk to you about the Singapore Convention. I wanted to show you a picture of Laura and me at the Singapore Convention. And that's where we met the last year, the signing ceremony. And at the end of the ceremony, we walked to the signing table and we just took this picture. So I just wanted to show you because that was a really significant moment, and we love to be in the Singapore signing ceremony. So before we start, I just wanted to show you this amazing quote that if you love mediation, and I assume you do, if you're listening to this presentation, you're gonna love it. And an ounce of mediation is worth a pound of arbitration and a ton of litigation. And that's just to start my presentation. I would like to just give you some inspiration and share some love for mediation. So before we start, let me give you an agenda or an overview what I'm gonna talk about it today. So first, I would like to give you a background of the Singapore Convention, and then I will dive deeper into the terms of the Singapore Convention, and I'm gonna give you a general overview of the main and the core terms. And then I would like to talk about what is next and what is the future and what will be the practical effects and opportunities that the Singapore Convention will bring. So with that said, let me go ahead and start. So before we start talking about the background, I think it's important to talk about the role of mediation in the global system of dispute resolution. And why? Because that explains that basically help us to understand why we ended up with Singapore Convention. Well, mediation has not had a major role in international commercial field. In cross-border commercial transactions, international arbitration has been the preferred dispute resolution mechanism. In fact, the vast majority of international commercial contracts always mandate arbitration. And why is that? Well, parties to an international contract dispute had been reluctant to choose mediation normally due to 2 primary reasons. First of all, settlement agreement resulting from a mediation provides no finality. Aside from cases where a mediated agreement happens in the context of a pending arbitration, where the mediated agreement can be converted into an arbitral award. This mediated agreement is essentially a private contract with no additional legal status of transnational privilege. In consequence, parties can only enforce the agreement in the same way as any other private contract, going to court. So, for example, in the US, the states that have adopted the Uniform Mediation Act, that is adopted in pretty much half of the states in the US, don't provide any specific enforcement provisions for a mediated agreement resulting from an international mediation. This agreement is simply a contract, and these jurisdictions allow for a contesting party to raise typical contract defenses, such as incapacity, mistake, duress, and undue influence. And that's why parties don't want to replace sometimes one unreliable and breached contract with a mediated one, since an already breaching party could just ignore the new contractual obligation coming from the mediated settlement agreement and create an additional layer of litigation. And the second reason that explains why mediation is not commonly used for the resolution of international commercial disputes is attributed to the fact that mediation didn't have a legal regime for the enforcement of the mediation agreement across different jurisdictions, such as the New York Convention for Arbitral Awards. So let's talk about the New York Convention, because I think to understand why the Singapore Convention is such a significant treaty, we have to understand the significance of the New York Convention. So, well, the New York Convention, it was adopted in 1958 and it went into effect in 1959. It has been described as the most important and successful treaty in international trade law, and is largely responsible for the prevalence of international arbitration as a dispute resolution mechanism across the globe. And as of June 2020, the convention has 164 state parties, which includes 160 of the 193 United Nations members. That's practically 85% of the countries in the world. But the most impressive thing about this treaty is that is the global reach of the convention. It basically turned international arbitration and basically made arbitration so prevalent and the number one alternative of dispute resolution in international commercial disputes. And why exactly this? What exactly this International New York Convention is about? Well, it basically requires that contracting states they need to recognize and enforce arbitral awards as domestic awards by converting them into a judgment enforceable by a national court. And that basically is the goal. So basically ensure that the contracting states uphold the arbitration agreements by the parties, and they will honor all the arbitral awards resulting from an international arbitration. That is basically the critical reason and the number one reason why international arbitration becomes so popular. Just the knowledge that an arbitral award can be enforced by the coercive powers of the courts in countries around the world also encourages voluntary compliance. A well-respected academic study found that 9 out of 10 awards are satisfied without the need for enforcement proceeding. That's just amazing. Other factor that we have to, that is important to talk about, is the Global Pound Conference series, because that influenced too in and was part of the reason why we ended up with the Singapore Convention. But what is exactly the Global Town Conference? Well, this unique project had an objective, and the objective was to find out how civil and commercial disputes should be resolved in the 21st century, concentrating only on the needs of corporate users of dispute resolution. These conferences brought together over 4,000 people from across the spectrum of dispute resolution stakeholders at 28 conferences in 24 countries. I was lucky to be participating in one in Los Angeles a couple years ago, and Singapore held the inaugural conference. But 4 key findings were identified from the extensive data collected during this series. So first, efficiency. For corporate users of dispute resolution, efficiency is the key priority. And the second key finding was parties expect greater collaboration from advisors in dispute resolution. The third one, there was a global interest in the use of pre-dispute protocols and mixed mode of dispute resolution. That means mediation, arbitration, ARP-MED, any mixed mode. And also, the Global Town Conference key finding was that corporate users wanted a wider use of mediation to navigate the difference between different jurisdictions. So that's why we ended up with the United Nations Commission International Trade Law, UNCITRAL, because in fact, the US and Tim Schnabel at the US Department and the State Department, he brought a proposal to UNCITRAL on a proposal about creating an international framework for the enforcement of international mediation agreements. And this proposal was embraced by the United Nations Commission on International Trade, UNCITRAL, and they created a working group. It was called the Working Group 2. 85 member states were part of this working group. In 2015, they start working and negotiating and drafting the terms of the convention of this framework. And in December 2018, the United Nations General Assembly finally adopted the United Nations Convention on International Settlement Agreements Resulting from Mediation, also known as the Singapore Convention on Mediation. And it was decided that it will be open for signature on August 7, 2019 in Singapore. So what is the scope and what is the application of the Singapore Convention? Well, Article 1st of the Singapore Convention has a very narrow focus. A narrow focus is a scope, because it does not apply to any agreement between just commercial entities or any agreement that just 2 companies reach. The convention only applies to international commercial agreements resulting from mediation. So if, for example, 2 companies or 2 commercial entities, they have a dispute and they directly and verbally, they just reach an agreement and they try to later to enforce the agreement under the Singapore Convention, the Singapore Convention won't be applicable because in this case, the agreement wasn't resulting from mediation. So remember, those elements are very important. The Singapore Convention will only apply to international commercial agreements that they have to be resulting from mediation. The convention also excludes agreements that are resulting from a court proceeding or concluded from personal, family, household purposes, family, inheritance, or employment law cases, and or cases that are enforceable as judgment, or are or agreements that are enforceable as an arbitral award. And here it's important to talk about the California International Arbitration and Conciliation Act, because the drafters of the Singapore Convention, when they were excluding the arbitral awards from the scope of the convention, they were thinking about jurisdictions like California, that they have laws like this. Under the California International Arbitration and Conciliation Act, any mediation resulting from an international mediation, and any agreement resulting from this international mediation is treated as an arbitral award for enforcement purposes. And that's why that was the way that California was trying to circumvent the need for enforcement of mediation agreements resulting from an international mediation, because there was no convention and no applicable legal framework to enforce it. So since we have the New York Convention that was enforcing arbitral awards, so California decided to treat mediation agreements resulting from international mediation like an arbitral award. And that's why the Singapore Convention keep that in mind. And this law came into effect in 1988, and 10 years later, other states in the US adopted the same type of treatment for international mediation agreements, because they wanted to provide some security to the parties that the mediation agreement will be enforced. So we have Texas, we have Ohio, North Carolina, and Oregon with similar laws to the California International Arbitration and Conciliation Act. But let's talk about now what is the core of the Singapore Convention, and that is basically Article 3. Article 3 basically states that each party to the convention shall enforce a settlement agreement in accordance with its own rules and procedures and under the conditions laid down in this convention. So basically, the Singapore Convention is acknowledging that there are many approaches to enforce mediation agreements in every country in the world. So it's basically letting every country decide how they're going to do the enforcement of every mediation agreement. At the same time, Article 3.1, this is the second paragraph, provides an enforcement, well, the first paragraph, it provides an enforcement sword. The second paragraph, 3.2 of the Singapore Convention, creates like a defensive shield, because allows a party to invoke the agreement to prevent a dissatisfied counterparty to the agreement from later litigating a matter that was already resolved by a settlement agreement. So the drafters understood this to be a complete defense and not just an evidentiary rule to admit the agreement into evidence. Thus, under the Singapore Convention, parties to a mediated agreement can have confidence that they won't have to relitigate an issue if a party refuses to comply or tries to drag the settled dispute back into court. And the interesting part is that Article 3rd of the Singapore Convention is basically mirroring the Article 3rd of the New York Convention, where each contracting state basically is letting each contracting state recognize arbitral awards as binding and enforce them in accordance with their own rules and procedures. So the core terms of the Singapore Convention is basically replicating what the New York Convention did for arbitral awards. Another important term in the Singapore Convention is Article 2 of the convention, where basically defines what is mediation. Because remember, the Singapore Convention only applies to international settlement agreements resulting from mediation. So that's why they define what is mediation. And at the same time, they acknowledge and they recognize that different terms may be used around the world to refer to mediation. For example, in California, sometimes, like I just showed you, they are people that call the mediation conciliation. I call it mediation, but laws like the one that I just showed you, so they refer to mediation as a conciliation. So Article 2 of the Convention defines mediation as a process irrespective of the expression used whereby the parties attempt to reach an amicable settlement of the dispute with the assistance of a third person or persons, the mediator. But I think the essential element in this definition is that the mediator must lack the authority to impose a solution upon the parties to the dispute for the convention to be applicable. And why is that? Because if the person that is assisting the parties with resolving the dispute has any authority to decide, basically that is no mediation, that is arbitration. And because the arbitrator is the one with the authority to impose a solution on the parties, and so the agreement or what it will come out will be an arbitral award, a decision from this arbitrator, and no a mediation agreement that will be covered under the Singapore Convention. So Article 4 provides enforcement requirements. Just to ensure that an eventual agreement reached in an international mediation is enforceable under the Singapore Convention, a party must provide the competent authority from each country the following items. So first, the agreement that had to be signed by the parties, evidence that the agreement resulting from mediation, such as the mediator's signature on the settlement agreement, or a document signed by the mediator indicating that the mediation was carried out, or an attestation by the institution that administered the mediation, or in the absence of 1 and 2 or 3, any other evidence acceptable to the competent authority. So I think the drafters were very flexible about these requirements, because there are so many ways that you can prove that you reach an agreement in mediation and international mediation to make the Singapore Convention applicable. So let's talk about the grounds for refusing relief. And those are on Article 5 of the Singapore Convention. And they basically provide that country of the courts, or the signature country, may refuse to grant relief if proof is provided of the following: a party to the settlement agreement was under some incapacity, or the agreement is null and void, or inoperative, or incapable of being performed under the law to which the parties had validly subjected it, or is no binding, or is no final according to its terms, or has been subsequently modified, or the obligations in the settlement agreement have been performed already, or are not clear or comprehensible, or granting relief will be contrary to the terms of the settlement agreement. Another interesting ground for refusing to grant relief, it has to be with the mediator. And after being at the Singapore Convention signing ceremony and in many discussions about this convention, I think this is the most controversial part of the Singapore Convention, because basically involves the mediator and his conduct. If there's a serious breach by the mediator of the standards applicable to the mediator or the mediation, without which breach that party will not have entered into the settlement agreement, the relevant authority may refuse to enforce that agreement. Or if it was a failure by the mediator to disclose to the parties any facts that made the mediator impartial or no independent. Basically saying that if the mediator didn't disclose any conflicts of interest or there were serious doubts as to his impartiality, so that will be a ground for refusing to grant relief. That's why one of the reasons it is important to develop really efficient and simplified and uniform mediation standards around the world because of these provisions in the Singapore Convention. But let me talk about the Singapore Convention, the signing ceremony, because I think this was an historical moment, and it was a pretty amazing event hosted by Singapore. Let me tell you, I'm a big fan of Singapore after being there for the Singapore signing ceremony. They were amazing. They were terrific host. And they invited hundreds of government officials, business executives, legal practitioners, ADR professionals, academics from around the world to witness the signing and to discuss emerging issues relating to ADR and international trade. And they provided not only one day of events, they have a whole week, and they call it the Singapore Convention Signing Ceremony and Conference, and it was from August 2nd to August 9th of 2019. And I was very lucky to be invited by the Singapore Convention and witness this historic event. This is where you can see the Shangri-La Hotel, where the Singapore Convention was signed. We have first the Singapore Prime Minister Lee Hsien Loong is speaking to the audience, and then each country was called to the signing table and it started to sign. So here we have a picture of all the signatory countries, and we have here 46 states that they made the Singapore Convention one of the most successful conventions developed by the United Nations Commission of International Trade Law, because in terms of signatures, opening day, this was amazing to get 46 countries to sign on the first day that it was open for signature. And just to give you an idea, the New York Convention, it was signed only by 10 countries the day when it was open for signature in 1958. And it took 10 years to get ratified and signed by 32 countries. So this is pretty amazing that the Singapore Convention got 46 countries signed on opening day. And here's a list of the first 46 countries that signed the convention. I was very surprised that many of the members of the working group, remember I told you that 85 countries were working, were drafting and negotiating and were part of the working group from the UNCITRAL, and that they drafted the Singapore Convention. Well, many of those countries weren't part of the, they were here and they didn't sign the first day. And so we missing to the European Union countries, because what I heard was that the European Union couldn't determine if each individual country needed to sign or the whole bloc needed to sign, so they couldn't figure it out at that time. And besides, UK was dealing with Brexit, so I guess they were busy with dealing with Brexit, and they couldn't, and they didn't sign it. Other countries that are missing here are Canada, Mexico, Australia, Brazil, Argentina, and other countries that they were part of the working group. Later on, we have more countries, and we have 5 new signatories. They were Armenia, Chad, Ecuador, Gabon, and Guinea-Bissau. And so now we have, as of June 24, 2020, and after checking the IMI website, I realized that we have 52 countries that have signed the Singapore Convention. And here's a good map that you can find on the IMI website, that shows you the countries that have signed, the countries have ratified, the countries that have done nothing regarding to the Singapore Convention. So, and the countries that have already ratified are 4: Singapore, of course, Fiji, Qatar, and Saudi Arabia. They ratify back in February. So what is next? Well, the convention will enter into force 6 months after 3 states have acceded or ratified the convention. And like I just said, the convention has been ratified by 4 countries already. So it started in February with Fiji, Singapore, and Qatar. So so the Singapore Convention will enter into force in September, according to the provision. And so, but what is it? What we can do now, and what is next? How do we get more countries to sign it and ratify it? Because just like it happened with the New York Convention, I think it is going to be successful, and is going to have more impact if more countries ratify it and sign it. Well, I guess it's all up to us as mediators and ADR professionals and people that love mediation and conflict resolution to educate and promote the Singapore Convention. And this is one of the reasons I love to talk and discuss about the Singapore Convention, because it's up to us to spread the word and educate everyone and tell them about the benefits of mediation, the benefits of signing this convention and getting it signed and getting their country signed and getting the support of politicians and businesses and policymakers and end users and lawyers. And it's important to talk to corporate counsels and lawyers that are drafting contracts and agreements, to be sure that they incorporate mediation clauses into their contracts, and in that way mediation start being more used and popular, just like it is international arbitration nowadays. Because I believe that now more than ever, we need mediation and we need conflict resolution, and we need to promote ways to resolve disputes in the states, for example, and I'm pretty sure everybody's dealing now with the same circumstances, besides having to face a health crisis with the coronavirus and the pandemic. We have now, I guess, is a global social unrest, and like everything started from George Floyd's death and the protest and the civil unrest that is becoming global right now. And I was just amazed to see in the news how everything is spreading all over, the civil unrest and the people protesting and the people dissatisfied with the way everything is. So our world, what is needed now more than ever is 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 is, is mediators and dispute resolution skills to facilitate dialogues and to help the world facing and dealing with these current issues that we're living with. And in the meantime, I think the good thing is that we can mediate online. We can use Zoom and many online platforms to mediate and to provide our services. And this is a picture of me the last week when my office just reopened. And so we came back to the office wearing masks, keeping everyone apart 6 feet. But I decided myself that COVID-19 or nothing will stop me. And I would just gonna keep doing what I love and keep helping, because that's the only thing we can do right now. So just remember, the benefits of this convention are very significant, because it will not only facilitate international trade and the promotion of mediation as an alternative method to resolving disputes, but it will be a huge step in encouraging the use of mediation of an international level, promoting it as an additional alternative to complement arbitration and litigation, and it will bring certainty and stability to the international framework of mediation. So that's what I will encourage all of you, just to talk and promote and educate and spread the word throughout the world after this Singapore Convention. And very involved with the American Bar Association, and this is one of the things that we're doing at the American Bar Association. Last February, in 17 of 2020, we have a mid-year meeting, and the House of Delegates approved a resolution. And this is what the resolution provided, that is basically saying that the ABA is urging all nations, including the United States, to become party to and implement the Singapore Convention, and is basically recommending and urging everyone to implement and become a party. So with that said, I would like to hear now from everyone and take some questions. And here's my contact information, just in case that anyone has any more questions. But Laura, I'll let you handle now the questions.
Great. Thank you, Anna, and thank you for a really comprehensive presentation. I think a lot of people, both on the webinar today, but also in future, will gain a lot out of it. And so the first questions, and we've got a couple in, and if anyone does have further questions, please pop them in the Q&A section. Firstly, one question that I'm going to answer. Devika asks whether a recording of the webinar will be available for the public. And yes, it will, probably by Friday on both the IMI and SIMI website and on YouTube. But now some questions for Anna. So Eric Van Ginkel firstly offers a slight correction. He says that Working Group 2 has been around for many decades, and earlier it dealt exclusively with arbitration. And with the development of the model law of conciliation adopted in 2003, it was extended to mediation. And he had a question here as well. What are your thoughts about the defenses of Article 5, which would not be admissible under Californian confidentiality laws? Suppose they will be admissible in the state where enforcement is, though. whereas the MSA was entered into in California.
If history is any indicator, I'm pretty sure that the Singapore Convention will do the same thing for mediation that the New York Convention did for arbitration. And I'm pretty sure it will help to promote and make mediation more popular and more common use in the international dispute resolution field, because that's exactly what happened with the New York Convention and arbitration. I don't know exactly what defenses of Article 5 he's referring to. So, but what I will say is that if the Singapore Convention is ratified by the US, it will become an international treaty. An international treaty preempts and obviously the US to ratify it will have to enact federal law, just like they did with the New York Convention. And this federal law will preempt any state law. So anything that that is contemplated under California law will be preempted by the federal law that it will be enacted after US ratified the Singapore Convention. On the second question, let me see, why few European countries? Well, like I said, the European Union, I guess, and that's what I hear, they haven't figured out how they're gonna sign. If they're gonna have each individual country of the European Union sign it, or they're gonna have the whole bloc. Because the European Union, from what I understand, they have their own mediation regulations, and they're applicable to the whole bloc of countries that are part of the European Union. So they haven't figured out the logistics of how they're going to do it, and that's what they haven't signed it yet.
There's one from Alejandro Asuna.
Oh, Alejandro, that's
Yep.
my great friend from Tijuana, Mexico. Alejandro, let's see, where is the question? And questions and answers?
Yeah, it's okay. I'll read it out to you if you'd like. It's quite a short one.
Yeah.
Do you think that ratification of the Singapore Convention will bring with it the adoption of the UNCITRAL model law on mediation?
Oh, yeah. And at least this is the way it works. Normally, the Singapore Convention provided a model law that countries can use to develop and draft their own law to implement the Singapore Convention. So, and that's what I think is super important to understand and know about the New York Convention, because every time that that you think about it, like, oh, how exactly we're going to implement and apply? Well, look at the New York Convention and look what they did. And in the case of the US, just like I said, and in fact, the New York Convention was ratified by the US 10 years later after it was adopted. What basically they did is they enacted a federal arbitration act, and that was drafted after the model law that was provided by the New York Convention, and they provided how they will implement the New York Convention in the US. So that's the way that normally that it will be implemented in every country, adopting the model law and just developing some legislation. In case, for example, of Mexico, what I would recommend is to first try to convince the country to sign it, because they haven't even signed it. And once they sign it, they have to ratify it. And after they ratify, they have to implement it, and they have to hopefully use a model law and trying to develop legislation to implement it. that's what I would recommend.
Super. And so I have some questions for you as well, Anna, because you've just mentioned that Mexico hasn't signed the convention, but of course the US also hasn't signed. I mean, what do you think, firstly, what do you think the benefits of signing actually would be for the US?
First of all, I want to clarify, the US signed it, and it was in fact the one that proposed this Singapore Convention, remember? Yeah, but haven't ratified. Yeah. That's the difference. So yes. The US, their process of, and like I said, we here at the American Bar Association, we're trying to promote and push and trying to convince the government of ratifying it. And what I understand, my understanding is right now, the treaty have to be reviewed by the executive branch and by the State Department. And then once it's approved and reviewed, they go to the Senate for ratification. So the whole process takes a while for any treaty to re-ratify. And like I said, in the New York Convention case, the US took 10 years to ratify it. So imagine, exactly. But what I say is, I think so we're in good shape in comparison to the New York Convention, because look, we have 46 countries signed the first day. It took 10 years for the New York Convention to get where we got in the first day. And so I'm pretty optimistic that we can get it ratified by the US as soon as hopefully everything can get normalized. I think a lot of things got delayed because of the pandemic, and now with everything else that's going on in the country and the civil unrest, I think the government has a lot going on, but I'm pretty sure it's going to happen. But in the meantime, what I would recommend, and especially to people that is from different countries that they haven't even signed it, is to start promoting in their own countries, like in Mexico. And that's what I refer to Mexico, where I have many friends like Alejandro, and I always told them, I was like, please talk to somebody in the government and trying to help them to understand how important it is for the country to sign it and ratify it, because that's the first step to get countries to sign it. And that's why my call is to all mediators and mediation lovers is to help us to spread the word and educate people and convince everyone about the benefits of mediation and the benefits of the Singapore Convention.
Great. And we have a question here. We will wrap up shortly. We've got a question here from Matthias Poniatowski, who asks, can the mediation agreement be certified in all countries?
Can the mediation agreement be certified in all countries? Yeah. I don't know what he means by certified, but okay, this is the way it works. Okay, the Singapore Convention basically provides that if the country sign the Singapore Convention and ratify it, they are obligating their courts to enforce any mediation agreement that comes to them for enforcement. That's basically what it is. It's no certifying. It's no. It's basically just making it eligible for enforcement. But remember, if the country doesn't sign, the country is not part of the Singapore Convention, we can force them, we can force their courts to enforce a mediation agreement in this country. So that's why that's what is so important, to get more and more countries to sign it and ratify, because the more countries ratify it, we get more parties to the agreement, and eventually, like it happened with the New York Convention, we have 85% of the world being a part of the agreement of the convention. So that will make it so much easier because international trade, people will start using mediation more because they have the reassurance that if they enter into an agreement or a mediation agreement with a party from this country that have signed the Singapore Convention, they have the reassurance that that mediation agreement will be enforced by the court of that country.
Super. He sort of corrected the question a few times, but I think you've definitely answered it there. So, but I am going to co-opt his question because he asked about certification, and being this is an IMI SIMI webinar, I mean, what role do you think that things like standards and certification of mediators have to play via the Singapore Convention?
Okay, so we're talking about certifying mediators. So, well, I think this Anna, I think is always to get certified by, like, for example, the International Mediation Institute, and in fact, I'm certified by the International Mediation Institute because I think so that's the future. And when the Singapore Convention will be eventually signed for more countries, certified international mediators will be in high demand. And so I think so this is the prime time to get certified, to get your international credentials and prove yourself that you have the experience and the credentials to handle international mediations.
Absolutely.
And full disclosure, they haven't paid me anything. I just love mediation. I just love promoting the Singapore Convention, and I love the International Mediation Institute.
Yeah, she doesn't work for us, I promise.
Exactly. And they haven't paid me anything. So full disclosure, no.
Great. Well, thank you so much for your presentation. And I think it was brilliant. We've got a comment here from Enrique Hernandez who says, congratulations, all caps, for the excellent presentation. And I think we can all agree with that. So thank you so much for lending us your knowledge and your expertise today. It's been a pleasure having you here with us.
Thank you. Thank you, everyone. Thank you, Jessica.
Perfect.
Thank you, everyone.
Thanks all. We'll see you next time.